seek to understand whether or not the two systems have an exchange relationship conceptually and practically. I'm honored to present our distinguished guest speakers for today, but before doing so, I was notified that one of our participants, Dr. Fahd Sharif, is unable to join us. The guest speakers for today include Ambassador Khalid Khalifa, the representative of the United Nations High Commissioner for Refugees to the States Gulf Cooperation. In addition, Dr. Charlotte Lisa, who is a postdoctoral researcher at the University of Oslo and also a visiting fellow at the King Faisal Center. In addition, we have with us as well Dr. Misfir Al-Qahtani, who is a professor in the Department of Islamic and Arabic Studies at King Fahd University of Petroleum and Minerals. As well, we have Dr. Dala Stephen, who is a professor of refugees laws in the School of Law at the University of Warwick. With that, I may ask Ambassador Khalid Khalifa to share with us his opening remarks about the today panel discussion. Please, Ambassador Khalifa.
Thank you very much, Dr. Muhammad. Assalamu alaikum wa rahmatullahi wa barakatuh. It's a real pleasure to be with all of you today. The topic is quite close to my heart, and I'm looking very much forward to listening to my co-panelists and learn from their experiences. Esteemed guests and speakers, ladies and gentlemen, Article 14 of the Universal Declaration of Human Rights stipulates that everyone has the right to seek and to enjoy in other countries asylum from persecution. And the 1951 Convention relating to the status of refugees and its 1967 protocol are at the core of the international protection system. They are complemented by regional treaties and declarations addressing the rights of refugees. Together, they constitute international refugee law, but the latter cannot operate in isolation. There is an increasing need for international solidarity and sharing of responsibility to guarantee the protection of asylum seekers, IDPs, refugees, and provide them with the necessary life-saving interventions. The notion of international protection is deeply enshrined in the Quran. Whenever I actually think about international protection, the more I think about it, the more I believe that those concepts stemmed from Islamic teachings. Prophet Muhammad sallallahu alaihi wasallam was himself a refugee, as we all know. He fled persecution in Mecca and searched asylum or sought asylum and protection in Medina. The unprecedented tale of Al-Ansar, the supporters of the Prophet, and the kind of help and assistance they extended to their fellow believers is a lesson learned and a good example, a good practice that we all aspire to reach. In Surah Al-Anfal, verse 74, Allah subhanahu wa ta'ala says, وَالَّذِينَ آمَنُوا وَهَاجَرُوا وَجَاهَدُوا فِي سَبِيلِ اللَّهِ وَالَّذِينَ آوَوا وَنَصَرُوا أُولَئِكَ هُمُ الْمُؤْمِنُونَ حَقًّا لَهُمْ مَغْفِرَةٌ وَرِزْقٌ كَرِيمٌ. This translates into those who believed and have migrated and strove in the way of Allah, and those who hosted them and gave them refuge and support. Allah says that those are the true believers, and He joined them in one category. A quick examination of Quran and the Sunnah reveals many of the principles of the contemporary refugee law principles. Both consider the provider of shelter to an asylum seeker a true believer and stipulate offering asylum to those who seek it unconditionally and regardless of their religion. UNHCR commissioned a study that was produced a few years back, more than 10 years ago, actually, by Professor Ahmed Abul Wafa, who was the Dean of the Law Department in Ain Shams University in Cairo. And this book is now considered a reference in comparing Islamic law with international refugee law. And it is an indication and a proof that a lot of the teachings that we are talking about now have actually roots in Islam and the Islamic teachings. Article 33 of the 51 Convention stipulates that states are responsible for protecting the rights of their citizens. And this is an important point to make sure that we are not letting governments off the hook. Yes, we are talking about teachings, about assistance, about how religious people should assist each other and should accept the strangers, if we can call them as such. But the main responsibility for protection lies with the state, lies with the government. And the civil society steps in when the government is not able or not willing to provide such assistance. There are now more than 84 million people who are forcibly displaced around the world. And this is a huge, scary figure. Those people were forced to leave their homes by conflict because of violence and because of persecution. But the number itself is not the end of the story. 60% of this total come from the member states of the Organization of Islamic Cooperation, from Muslim countries, 60%. And this is a very disproportionate distribution of needs around the world. Most of those displaced are eligible to receive zakat from the Muslim world. If we are talking about financial assistance, they actually fall within the 8 categories mentioned in the Quran. And usually when I speak about zakat and refugees, I say that all the categories apply to refugees, even the category that relates to freeing slaves, which does not exist in modern world. But if we think that refugees and forcibly displaced people are enslaved to their situation, then they are eligible even under this category to receive zakat. Throughout the Arab and Muslim world, Islamic principles and Arab customs and traditions have for a very long time served as a solid foundation for protecting human beings and preserving their dignity. Notions such as istijara, plea for protection, ijara, granting protection, iwa, shelter, and other concepts are variations of the notion of protection, which is at the heart of UNHCR's mandate. There's certainly a multitude of similarities between Islamic law and international refugee law. I will leave the floor to my co-panelists. I just wanted to highlight the fact that a lot of the teachings we are talking about in modern history have roots and stem actually from religious teachings in Islam. Thank you very much. And the floor is back to you, Dr. Muhammad.
Thank you, Ambassador Khalid, for sharing some very interesting and historical point of views from the Islamic perspective on our subject today. Now I will turn the microphone to Dr. Charlotte, who's going to present some of her thoughts about the Rafa case in our subject today.
Thank you so much. And first of all, let me thank the organizer for the opportunity to to participate in such an interesting discussion in such an important topic. Let me also take the opportunity to thank my panelists, my co-panelists for participating today, and not least for everyone who logged on to take part in this webinar. So let me first say that Saudi Arabia is not party to the 1951 Convention relating to the status of refugees and the 1967 Protocol. And stereotypically, Saudi Arabia is seen as somehow disengaged with international refugee law, and in European media narratives as a country that simply does not host refugees. In Saudi Arabia, you often encounter ideas about international refugee law as perhaps not suitable for the Saudi system, relying instead on Islamic principles in dealing with refugees. Such assumptions are somehow based in the myth that these systems exist separate from each other. And I want to use the next minutes to make an attempt at challenging this based on Saudi Arabia's long history of engaging with the international refugee regime. In fact, Saudi Arabia was actively engaged already in the drafting process of the Refugee Convention, not only as a very important and continue to be actively engaged with the UNHCR. Not only as a very important funding partner, but through fora such as the UNHCR Executive Committee meetings. So in this webinar, as Mr. Mohammed said, we ask about the relationship between international refugee law and Islamic law in theory and in practice. And for my presentation, I will focus on the in practice part and attempt to offer some empirically based reflections on how the international refugee regime, so law, norms, institutions such as the UNHCR, works in tandem with traditional and Islamic concepts of humanitarianism and asylum in the case of Saudi Arabia. More specifically, I will present on the case of the Rafa refugee camp. So in the Rafa situation, the Saudi government provided humanitarian assistance and secured the basic need of refugees, while UNHCR undertook an important role by monitoring and advising on the situation, with established field offices in the refugee camps and organizing the resettlement of the refugees to third countries. So this case explores the intersections of international refugee law and Islamic concepts of asylum and hospitality in practice through how these were adopted in this specific case. So I'm basing this presentation on my ongoing research as a postdoctoral fellow on the Rafa project financed by the Research Council of Norway and led by Professor Maja Jammir at the University of Oslo. And what I'm presenting today draws on interviews with former refugees and others with knowledge of this specific situation, conversations with officials in Saudi Arabia, and archival material from the UNHCR. So let me take a step back to 1991. And in her memoirs, UN High Commissioner for Refugees, Sadako Ogata, recounts the Gulf War of '91 as a major watershed in the development of multilateral diplomacy and humanitarian action that set the stage for the post-Cold War period of the 1990s. More than 5 million people were forcibly displaced in relation to the war and the uprisings that followed. By mid-March '91, more than 1.3 million refugees had crossed the border into Turkey, and another 450,000 in Iran. At the same time, another lesser-known refugee situation developed in the proximity of the Saudi border, where around 30,000 Iraqis sought protection from Saddam Hussein's army. Now, as we know, Saudi Arabia had at this point already hosted a large number of Kuwaiti refugees fleeing the occupation. But the situation of the Iraqi refugees was different from that of the Kuwaiti refugees on many levels. They sought protection in the zone controlled by the US Army, who was preparing to withdraw and return home. Considering the level of violence exerted by Saddam Hussein's army, international organizations could not protect the refugees within the borders of Iraq. Kuwait did not have the resources to take in the refugees, and after intense efforts to find a solution to the very immediate and serious situation, Saudi Arabia decided to welcome the refugees, who were then airlifted or transported by land by US military to camps in Saudi Arabia. After given entry to Saudi Arabia, these refugees were initially hosted in 2 refugee camps under the Saudi Ministry of Defense and Aviation, Artawiya housing males designated as former prisoners of war, and the Rafa camp hosting mostly families. Well, the Artulia camp was closed down in 1992, and remaining refugees given a refugee status and moved to Rafa. The majority of Iraqi refugees were relocated or repatriated with the assistance of UNHCR in the years following the establishment of the camp. A number of Iraqis were left in Rafah until 2005, when UNHCR negotiated a deal with the Saudi authorities, who for the first time authorized the resettlement of about 300 in urban areas, providing them with refugee identification cards, access to healthcare and education, and allowing them to work. The camp closed down in 2009. So these camps were fully funded by the Saudi government. And materialistically speaking, the conditions in the camp were sufficient, or as stated by UNHCR at the time, and I quote, considered the best in any refugee camp situation in the world. The authorities provided the refugees with air cooling, food, clothes, a monthly allowance, and even cigarettes in addition to healthcare and schooling. On the other hand, the refugees had little or no freedom of movement, and the situation was, especially in the beginning, described as prison-like. They were not able to work outside of the camp, and there was no option of permanent settlement inside Saudi Arabia. In the months following the settlement of refugees in the camp, clashes with the unexperienced Saudi military guards following refugee protests left many refugees injured or even killed. The incidents then led the UNHCR to take on a more active role in relation to the camp. Now, when this situation emerged, the situation of the Iraqi refugees seeking asylum in Saudi Arabia had no established procedure or experience with handling such a situation. Some assistance have been given on ad hoc basis in response to the situation of particular groups, such as Palestinians and Rohingya for more than 40 years. But the refugee situation in 91 was different than any previous experience. It was immediate and critical. It was a very sensitive political situation involving a neighboring country. It had a security dimension, considering it happened in the context of war. And maybe most importantly, it was international at its core, developing following a multi-state military operation where Saudi Arabia had itself been a part. The UNHCR had in practice no prior presence and exceptionally limited information upon making the first mission in April 1991, the UNHCR Special Envoy would later recall. So, in a pamphlet published by the Saudi Embassy in London in 1993, I believe, it is declared that the Iraqi refugees were welcomed, and I quote, due to the bonds of brotherhood and neighborliness, and on the grounds of Islamic belief. Likewise, the UNHCR regional director at the time stated that the Saudi government were acting on a true humanitarian basis, and its charitable treatment of these refugees stems from the teaching of Islam, which calls for all Muslims to help each other. It is repeatedly made clear in statements and through practice that the means of protection in the Rafa case is developed and executed in close cooperation with the UNHCR, who oversees the situation and ensures the compliance with international law. The UNHCR thus adopted a role as a coordination body and body overseeing the implementation of established principles and norms forming the basis of the work of the organization. In addition to monitoring and advising, UNHCR took responsibility of finding permanent solutions for the refugees in third countries. Now, the guiding ethical principles influencing the Saudi government decisions might very well be based in existing Islamic value systems, while the mechanisms, instruments, and applied norms was adopted also from the international refugee regime. Well, these points of connection between the international refugee regime and Saudi Arabia as a non-party state to the Refugee Conventions are made particularly visible through the Rafa camp. It is not unique, but rather follows a long history of exchange. So as mentioned, Saudi Arabia was actively partaking in the drafting process of the convention and have frequently participated in meetings of the UNHCR Executive Committee as an observer state. And it should be mentioned that the Rafa case is unique in multiple ways. It stands out as the only camp settlement in the modern history of the Saudi state. However, the rhetoric of hospitality as well as the temporary status mirrors that of other groups. And my colleague, Dr. Fahad Sharif, who unfortunately could not join us today, argues in his book with Dr. Joseph Kachachian that the experience with the Rafa camp situation have actually led the Saudi government to prefer other responses to later refugee situations and avoid new refugee camps. Finally, this case led to a much stronger working relationship between Saudi Arabia and UNHCR. UNHCR signed a memorandum of understanding with Saudi Arabia in direct relation to the camp situation and opened a permanent office in Riyadh, still operational today. So just as the Gulf War was a watershed moment internationally, I argue, the Rafah situation was a watershed moment in the relationship between Saudi Arabia and the international refugee regime. Thank you very much.
Thank you, Charlotte, for providing such insightful comments and ideas about the subject of Rafah camps and Saudi Arabians' takes and participation, although not being a member or among those who signed the Geneva Convention in 1951 and neither its protocol in 1970s. Now we will be moving to our next speakers, Dr. Misfeh, who's going to talk in Arabic. Thus, I'm going to let everyone who would like to hear English translation to activate the button of interpretation down below the screen. Dr. Misfeh, please join us.
السلام عليكم ورحمة الله وبركاته. بسم الله الرحمن الرحيم. في البداية أقدم الشكر الجزيل لمؤسسة الملك فيصل على إتاحة الفرصة للمشاركة في هذه الندوة الهامة التي تجمع بين القانون الدولي والقانون الإسلامي في معرفة حقوق اللاجئين. في البداية أيضا أود أن أعتذر وعدم التهيؤ المكاني وكذلك اللبس الملائم لحضور مثل هذه الندوات الجديرة بأن تكون وفق الأطر الرسمية المتعارف عليها. ولذلك سبب أود أن أذكره لكم في البداية، وهو أني قد سجلت كمشارك في مسار تاريخي معروف في الجزيرة العربية وهو درب زبيدة. وهذا المسار هو كمسار القوافل القديمة قبل 1000 سنوات، ثم بعد ذلك اعتبر هو طريق الحج الكوفي الذي يأتي من الكوفة وبغداد إلى مكة. وهذا الطريق قد اندثر منذ فترة طويلة، ولكن تمت إعادة تشجيع السير عليه وممارسة نوع من إعادة أهمية هذا الدرب تاريخيا، وكذلك تطبيقا لرؤية 2030 متعلقة بجودة الحياة. فنحن كممارسي للهايكينج اشتركنا في هذا الطريق وفي هذا الدرب. قطعنا حتى الآن مشيا على الأقدام أكثر من 340 كيلومتر، وبقي لنا القليل إن شاء الله الوصول. حقيقة أنا أردت من هذه المقدمة وأنا أسير في هذه الصحراء وأقطع هذه المسافات مشيا على الأقدام، ونسكن في خيام صغيرة ونأكل في الصحراء أيضا. لا أخفيكم أنني استشعرت كثيرا الآلام والمعاناة التي يمر بها الكثير من اللاجئين في العالم، حيث أن كاميرات التصوير وشاشات التلفزة قد نقلت لنا كثيرا من هذه المعاناة، الذين يقطعون دروب طويلة ويمشون أياما متواصلة في ظروف قاسية. أعتقد أنني ربما بشيء من المشاركة المعنوية حاولت أن أتجسد شيئا من هذه المعاناة، على الأقل لمعرفة ماذا يمر بهم من صعوبات جمة في هذا الطريق وهذا الدرب الذي اختاروه للهروب من أي اضطهاد أو معاناة. لذلك أعتقد أن ما أردت أن أكون في مكان غير المكان الذي أسير فيه الآن أنا وزملائي في هذا الدرب. في البداية أود التركيز حقيقة ونحن نتكلم عن حق اللجوء بين القانون الإسلامي والقانون الدولي المعروف، وهو الذي صيغ في معاهدة جنيف 1951، وأيضا جاء معه بروتوكول عام 1967 بروتوكول نيويورك، وأيضا المشاورات التي تمت تقريبا في 2001 حول إعادة أهمية بعض بنود هذه المعاهدة المعروفة. ولكن من ناحية القانون الإسلامي أو من ناحية الفقه الإسلامي، حيث أن القانون الإسلامي في الغالب كمصطلح يعتمد على التراث الفقهي وكذلك التشريعات والأنظمة التي تعود إلى هذا التراث. بالنسبة لو رجعنا إلى التراث الفقهي الإسلامي وتعامله مع هذه القضية، قضية اللجوء، فنجد أن هناك عدة مصطلحات ربما سعادة السفير قد تطرق إلى بعضها في بداية حديثه في هذه الندوة. فهناك مصطلح الحماية والإجارة والهجرة، وأيضا كلها قريبة من معنى اللجوء، وقد استخدم القرآن بعضا من هذه المصطلحات. فهناك قوله تعالى: وإن أحد من المشركين استجارك فأجره حتى يسمع كلام الله ثم أبلغه مأمنه. وهذه عليها كثير من كلام المفسرين الذين يحاولون أن يؤكدوا أن مبدأ الإسلام هو مبدأ أخلاقي في التعامل مع كل من يتعرض لأي ظلم أو يرغب في الحماية والحصول على الأمان. فالقانون الإسلامي القرآن الكريم قد أكد مثل هذا المعنى، وجاء أيضا هذا التأكيد من خلال ذكر ما حصل من استقبال الأنصار للمهاجرين بعد لجوئهم إلى المدينة المنورة. إن الله عز وجل وصف هذا بقوله تعالى: والذين تبوأوا الدار والإيمان من قبلهم يحبون من هاجر إليهم ولا يجدون في أنفسهم حاجة مما أوتوا ويؤثرون على أنفسهم ولو كان بهم خصاصة. هذه الآية فيها كثير من مكارم الأخلاق والمعاني السلوكية التي تبين آلية التعامل مع أولئك المضطهدين أو اللاجئين. كما أن القرآن أيضا بين في أكثر من مقطع لجوء موسى من ظلم فرعون، وكيف هرب ووصل إلى مدين، وكانت هذه القصة متكررة في القرآن لتبين صورة من صورة الاهتمام والعناية القرآنية بذكرها، وذكر كذلك بعض الأنبياء الذين هاجروا ولجأوا من ظلم تحقق له، كما في قصة إبراهيم أو لوط أو عيسى كذلك، وبشيء من الاختصار بالنسبة لعيسى عليه السلام. اللجوء أيضا حدث في عهد النبي صلى الله عليه وسلم لما هاجر الصحابة إلى الحبشة وذهبوا إلى النجاشي، وكذلك الرسول صلى الله عليه وسلم قد لجأ بنفسه إلى المطعم بن عدي لما عاد من الطائف وأراد الدخول إلى مكة وليس عنده أحد فطلب اللجوء. هناك اعتذارات تمت، ولكن المطعم بن عدي وافق على ذلك، وكانت الاعتذارات مبنية على حقوق قبلية سابقة وليست لأن العرب حتى لو كانوا معادين للرسالة السماوية التي أتى بها النبي صلى الله عليه وسلم، لكنهم فيما يتعلق بالجوار والحماية والأمان لمن يطلبها منهم فإنهم يجعلون ذلك من أصول الأخلاق التي لا ينبغي أن يعني يعتذر منها عربي أصيل في ذلك الحين. هناك قصة مهمة وكانت تحتاج إلى تفصيل مهم، وهو أن الرسول صلى الله عليه وسلم لما دخل إلى مكة فاتحا جاءته ابنة عمه أم هانة وقالت: يا رسول الله إني قد أجرت 2 من أحمائي. فقال لها عليه الصلاة والسلام: لقد أجرنا من أجرت يا أم هانة. فبمجرد أن أم هانة وافقت يعني طلبت من الرسول صلى الله عليه وسلم وعملت جوار وحماية ل2 من اللاجئين، أصبح موقفها حينئذ موقف ملزم لكل المسلمين أن يحموا ولا يتعرضوا بأي أذى لأولئك الذين دخلوا تحت جواره وحمايته. وأحد الروايات تقول أنه كان علي رضي الله عنه أخوها يريد أن يقتل أحد أولئك بسبب أنه كان قد سبقت منه يعني ظلم وجرائم في حق المسلمين، إلا أن الرسول صلى الله عليه وسلم قبل الجوار هانئ لهم جميعا. وهذا له تفسيرات كثيرة ولكن ليس محلها الآن، ولكن في المبدأ العام كان هناك اهتمام كبير جدا فيما يتعلق باللجوء وأن لهم حقوقا مكفولة في الإسلام. لعلي أختصر هذه الحقوق في الوقت المتبقي إلى نوعين من الحقوق: حقوق عامة وحقوق خاصة وحقوق استثنائية. أما بالنسبة للحقوق العامة للاجئين في القانون الإسلامي فهو حق الدخول إلى ديار المسلمين والإقامة فيه، ولا ينبغي رفض أمان هذا الإنسان اللاجئ المضطر بسبب أي اضطهاد أو معاناة أو خوف إلا لمسوغ. وهذا المسوغ ذكره مثل محمد بن الحسن الشيباني وغيره، أن يكون مقبولا لولي الأمر أو من ينيبه أو أحد من أصحاب الرأي في الدولة الإسلامية. وهذا المسوغ غالبا ما يكون شيء استثنائي، وإلا في الأصل فهو حق الدخول ديار المسلمين هو حق مكفول له. كذلك حق الحماية والرعاية له. ولكن أيضا ذكر محمد بن الحسن الشيباني والبهوتي وكثير من المالكية أن زوجته وأولاده ومن يتبع لهم كلهم يدخلون في مثل هذه الحماية إذا أرادها. فمعنى ذلك أن حتى العائلة تدخل في ضمن قانون الحماية في الإسلام. كذلك حقه في استعمال المرافق العامة، وهو إن كان لاجئا فله حق الدخول إلى البلاد الإسلامية، وكذلك استخدام المرافق العامة فيها من ناحية الدخول في التبضع في الأسواق ودخول الحمامات العامة والحصول على أماكن الرعي إذا كانت له يعني رواحل أو دواب يحتاجها في حياته، فلها أن ترعى في مراعي المسلمين، وهي كلها داخلة في ضمن هذه المرافق. كذلك له حق إبداء الرأي وحق الاجتماع بمن يتقاطع أو يتماثل مع ديانته أو قبيلته، بمعنى أن حق الاجتماع مكفول أيضا لهم، كما أن مسكنه ومراسلاته كلها محمية. أيضا له حق التنقل داخل الدولة الإسلامية بموجب هذا الحق في الأمان والحماية الذي أعطي له. هناك حقوق خاصة تتعلق بحقه في تكوين أسرته، أي الزواج وإقامة علاقة زوجية مع من أراد، وكذلك يعني بناء أسرة له، حماية شعائره الدينية وممارستها، وله كذلك أن يقيم في هذه الشعائر أماكن عبادة متخصصة، وهذا قد حصل كثيرا في الشام وفي مصر وفي شمال أفريقيا وغيرها من الدول الإسلامية في إبان يعني التاريخ الإسلامي الماضي. حقه في الملكية والمتاجرة وغير ذلك، وهذا أيضا كان ظاهرا في كثير من الشخصيات التي برزت، كانت في بداياتها لاجئة وأتت إلى الدولة الإسلامية، وأقصد بذلك كثير من اليهود، ثم بعد ذلك وصلوا إلى حتى مناصب رفيعة وتجارات يعني واسعة داخل الدولة الإسلامية، وهذا معناه أن كانت الحقوق مكفولة لهم في ذلك. طبعا أريد أن أبين أن هناك فيه ما يسمى بأهل الذمة، وهناك المستأمنون. أهل الذمة هم الذين يبقون في الدولة الإسلامية إبان دخول المسلمين إليها وفتحها، ويصبحون بالتالي مواطنين، وهذه المواطنة تمنح لهم في مقابل أن يدفعوا مبلغ يسمى الجزية. وطبعا هذا المبلغ الذي يدفع هو يعني لا يدفع من قبل الرجال القادرين على العمل ويذهب إلى بيت مال المسلم، بمعنى أن مبلغ الجزية لا تدفعه المرأة ولا يدفعه الأطفال ولا العاجزين عن العمل ولا الشيوخ الكبار. وهو مبلغ قليل في مقابل ما يدفع من مال الزكاة التي يؤخذ من المسلمين. فمال الزكاة يؤخذ من كل صاحب مال تحققت فيه شروط الزكاة أيا كان، صغيرا كبيرا امرأة، حتى من المجنون إذا كان له مال فإن وصية أو ولية يقوم بأداء الزكاة يعني. هناك أيضا من الحقوق الخاصة عدم إعادته إلى دولة الإقامة، وهذا وإن كانت قد نصت عليه الكثير من المواثيق وأصبح مبدأ معروفا. كذلك هناك أيضا في الإعلان العالمي الإسلامي، الإعلان الإسلامي أقصد بحقوق الإنسان أو ما يسمى بإعلان القاهرة، فقد نص في المادة 12 بعدم إعادة اللاجئ إلى دولته إلا وفق استثناءات معينة يقررها يعني نظام تلك الدولة التي ذهب إليها. وقد ذكر الإمام القرطبي وكذلك ابن قدامة نصا يعني في التراث الإسلامي، هذا قبل يعني في القرن الخامس أعتقد الهجري، أن إذا كان هناك من لجأ إلى الدولة الإسلامية وثم تم طلبه، فإن الدولة الإسلامية إن رأت في هذا الطلب ليس له مسوغ وأن الأصل أن يبقى حماية له وتحقيقا للعدالة فإنه لا يسلم. ولو قامت دولة هذا المضطهد بشن حرب على المسلمين فيجب على المسلمين الدفاع عنه وعن ديارهم، ولو تحقق في ذلك قتل للمسلمين أو انتهاكا للأموال، إلا أن مبدأ تسليم هذا الذي لجأ إلى الدولة الإسلامية يعتبر مبدأ مكفولا له ولا يجوز تسليمه ما دام مظلوما أو مضطهدا. لعلي في الأمور الاستثنائية وهو أن اللاجئ قد يعفى من الجزية ويعفى من الخراج غير الذنب وليس مستعملا، هو هو داخل في دائرة المستعمل، فهو معفي من دفع الجزية ودفع الخراج، وهذه لها تفاصيل لا أريد الدخول فيها. لعلي أختم بقضية مهمة أجد أنها يعني تحتاج إلى شيء من المبادرات، سواء كان على مستوى الأمم المتحدة أو حتى على مستوى الدول التي يلجأ إليها الكثير من العابرين أو اللاجئين أو المهاجرين وغير ذلك. أهمية المعالجة المسبقة قبل النزوح أو اللجوء. وأعتقد أن هناك فيه خطأ دائما يحدث، أن هناك فيه مشكلات قد تحصل في بعض الدول. هناك في قناعة كبيرة أن هناك في نسبة من أفراد المجتمع سوف يعانون من اضطهاد قد يدفعهم إلى الخروج بمئات الآلاف إن لم يكن بالملايين. أمام مثل هذا التوقع الذي قد يكون له يعني نسبة غالبة من التحقق في المستقبل القريب، كان ينبغي أن تتدخل مثل الأمم المتحدة أو بعض المنظمات الدولية في وقت مثل هذا النزاع أو هذا الخلاف قدر المستطاع. أنا أقصد أنه قد يكون هناك في حلول، اترك الظروف أو بعض الإشكالات التي قد تحصل لبعض اللاجئين وقد يصعب حلها، ولكن إن كان هناك فيه قدر من الإمكانية في إيجاد حل مسبق لنزع الفتيل أن تكون هناك مشكلة وأن يتحقق سلام في مثل هذه البقعة من المجتمعات الأرضية اليوم، فلعل المبادرة في ذلك مهم. وقد رأينا مثلا في أفغانستان حاليا محاولة لكثير من المواطنين بالذهاب واللجوء بعد دخول طالبان، وربما لو كان هناك في حلول ودية في التعامل مع مثل هؤلاء في البقاء
دكتور مصفى،
قدر المستطاع. نعم.
إذا ممكن بس تختم، تجاوزنا
طيب.
الوقت المحدد، تفضل.
طيب أختم بذكر نقاط فقط سريعة، أن بيئات اللجوء اليوم أيضا تحتاج إلى إعادة نظر، لأن أصبحت بيئات يقع فيها الكثير من الإشكالات الأخلاقية وتكون بيئة مناسبة لانتشار المخدرات والدعارة. كذلك هناك تقريبا 14 دولة إسلامية فقط التي وقعت اتفاقية جنيف، وأعتقد أن من المهم جدا أن يكون هناك في اهتمام من منظمة التعاون الإسلامي في دفع الكثير من الدول للاهتمام بحقوق اللاجئين، لأن أكثر من نسبة 60% من اللاجئين في العالم هي في هذه الدول. ممكن فقط توصيتين أختم بهما، وهي متعلقة حقيقة بما تم ذكره في بعض التقارير الإغاثية، أن هناك في مصاريف عالية جدا للمفوضية السامية للاجئين، قد تصل في بعض الأوقات إلى قرابة 40 إلى 50% من المساعدات. وأعتقد أن من المهم النظر في مثل هذه النسبة. كذلك النظر في وضع طالبي اللجوء الذين يذهبون بشكل يومي عبر السفن وعبر العوامات التي تخرج من شمال أفريقيا إلى أوروبا. لابد أن يكون هناك في برنامج عملي وسريع للحد من مثل هذا الأمر. وأعتذر إذا كنت قد تجاوزت الوقت، وأكرر شكري وامتناني لجميع المشاركين ولمركز الملك فيصل بالدرجة الأولى على إتاحة هذه الفرصة. شكرا لكم.
شكرا دكتور مسفر. Now we will begin with our next speaker, Dr. Dalal. Please, floor yours.
Thank you very much, and thank you for this opportunity to speak to you on something that's very important, and as I'll explain in a way we probably should have given much greater consideration to over many years. So I've got some slides, and I'm just going to share my screen. So hopefully people can see those. Let me know if there's a problem with that. So as it says on the screen, I'm just going to give some reflections and maybe provide a bit of a historical and legal context. And I think they will lead on quite nicely from some of the comments of the previous speakers. So I'm just going to cover three areas: a brief review of some of the literature, a discussion of something that's been touched on by the ambassador in relation to law, regional law, and of course some of the points about international law. And then I'm going to conclude on really what is at the heart, I think, of many of the issues raised by the discussions around Islamic law and international refugee law, looking at whether we're concerned with customs, principles, or norms. And in a sense, following on from the previous speaker, what should we be doing? What are our options really for the future? So hopefully I'll manage that in 10 minutes. So first of all, I've just got on there a whole range of different items from the literature. And the reason I've just flagged up some of these is to show everyone that actually there is quite a lot that's been written around the question of asylum, of refugee matters in Muslim countries in the Islamic tradition. And you'll see halfway down the piece that the ambassador referred to by Ahmed Abu al-Wafa, the right to asylum between Islamic Sharia and international refugee laws in 2009. But even before that, we can go back to the 80s and perhaps a little bit earlier to that first piece, again by somebody working at the UNHCR, Hassan Aranout, who wrote on asylum in the Arab Islamic tradition. But I think what's interesting from this list is that you can probably see around the 80s and the early 90s, we didn't have an awful lot of a discussion really about what we've heard about, the many important principles that come out of Islam. And it took quite a long time, I think, before there was an acknowledgement that actually many of the principles surrounding protection, safety, and sanctuary owed a lot to Islam. Many people working, of course, in refugee law come from countries of the global north and were more familiar, I think, with the concepts arising out of ancient Greece and Rome, and also within the medieval ages within Europe. So talked more about the origins arising out of those concepts of sanctuary, rather than actually acknowledging some of the influence that undoubtedly is there from Islam. But this list should encourage those of you that are interested that there has now been a resurgence or an acknowledgement of much more research undertaken on this issue. And as I say, I've highlighted quite a range of items on the screen there, ending with quite an important one, a recent one by Islamic Relief, who in 2014 published an item there, The Rights of Forced Migrants in Islam, which I would urge those of you who are interested in this area to read. It's not too long, but it comes from an organization that obviously has had a practical role to play in providing relief to refugees, but is also thinking about some of the issues that I'm about to deal with now. So certainly something we can say from the literature ought to have been discussed and written about much more and more recently, but thankfully we are seeing now this acknowledgement, this acceptance of the significance of Islam in relation to asylum and refugee matters. So as the talk, the webinar is about the comparison of, in a sense, principles from Islam, whether it's Islamic law or whether it is custom, and international law, I thought it would be also helpful just to highlight some of the aspects when looking at countries of the Islamic world as their relationship with refugee law, international refugee law, and I will come on to say a little bit about domestic law. Now, from the outset, we heard that actually there are quite a lot of countries from the Organization of Islamic Cooperation and countries in the Arab world who have not signed some of the core instruments under international refugee law. So the Refugee Convention of 1951 or the 67 Protocol. But there are some that have, and those countries are mainly based in North Africa and some others around the world. However, that does not mean that these countries have not been thinking about issues in relation to protection of refugees. What we find, however, is, as is shown on the screen, many of these are non-binding instruments. So they don't come out in the form of conventions or binding treaties, but tend to be in the form of principles such as the Bangkok Principles on the status and treatment of refugees, or, for example, the 1981 Universal Islamic Declaration of Human Rights. And again, I've listed, it's not a full list, some of the important instruments that have emerged from discussions either between countries of the Arab world or more broadly amongst Islamic countries. So we've heard about Article 12 already of the Cairo Declaration on Human Rights in Islam, very important provision there, which clearly indicates the rights of people to seek asylum and to obtain it. But we've also had something where we have seen Arab countries, for example, trying to reach that next stage of entering into a binding obligation, so that through the form of a convention. Unfortunately, many of these, although they are drafted and contain really significant and important principles, often do not enter into force after their final publication. And that's because countries then renege really on that final stage of actually introducing them and signing up to binding force. So an example of that is the 1994 Arab Convention on Regulating the Status of Refugees in Arab Countries. So that convention, as I say, does contain a lot that could be very helpful in providing greater certainty, not only for obviously individual refugees, but also for states as to what their obligations are. Now, there has been attempts more recently to reintroduce, if you like, the Arab Convention. You'll see at the bottom of the screen there, and discussions around about 2018. But as far as I am aware, this is still not entered into binding force. So one example is a certain concern by some countries, such as, for example, Jordan, which has reservations about the actual definition of a refugee that's contained in the Arab Convention, which actually is quite broad. So it's gone beyond the 51 definition. It's even gone beyond the definition contained in the OAU Convention to include many more aspects about public disorder. And so Jordan, certainly at this point in time, has not committed and is not prepared to sign up to this as a binding obligation. So what this tells us, and as we held also previously from Charlotte, is that many of these countries are engaged with discussions at a global level or even a regional level, are involved in even the 51 conventions drafting, but the drafting obviously of a range of other instruments, whether they are attempting to be binding through convention or certainly through declarations. Yet there is still that resistance. So they're holding back those that have not committed to signing up to the 51 Convention or 67 Protocol will not engage in that next step, and also even regionally are reluctant to actually introduce new binding obligations. So where we're left really is in this situation where there is now, I think, which wasn't the case certainly some time ago, of this acceptance and recognition of certain key principles of custom. So I think the handout for this webinar reminds us of the important tradition of hospitality, of treating people as guests. And we heard about those concepts of brotherhood and treating others as we would want to be treated ourselves. And of course, we've heard about the significance of Islam and principles such as Hijrah and Aman, and we've heard also of others. So we've reached that stage, I feel, that there shouldn't be any question about the importance of Islamic traditions, of principles of custom and religious principles that can guide a much more normative basis for protection of refugees. Now, I mentioned that while many OIC countries have actually acceded, for example, in Africa, there are still many others that have yet to do so. And I think that's roughly about right. I think there's still about 36 of 57 OIC member states that are signatories to the Refugee Convention. So clearly still a way to go to persuade any others. And I'm not sure the ambassador might like to comment whether actually we just have to accept now that many of these countries will not sign up if they have not yet done so. So that what this means from a legal position is that while we have the non-binding international instruments, many of these countries, even those who are party to the Refugee Convention, are heavily reliant on domestic laws, on, as we've heard, the United Nations High Commissioner for Refugees, to help out with refugee protection and refugee matters. Now, we've seen some movement recently, I think, where there seems to be a slow willingness of some of these countries to start to introduce what we might say are domestic laws that go beyond the law on the foreigners. So many of these countries, it will be familiar to those of you from Arab states, Arab countries treat much of the entry of refugees or asylum claimants as the same or under the same laws as other foreigners, and have not yet introduced even domestic law on asylum. Some might be relying on memoranda of understanding with the UNHCR. Some are, as I say, relying on foreigners' legislation. But fairly recently, Morocco, for example, in 2014, was one of the first countries of the Arab countries to actually introduce a national strategy for immigration and asylum. And there was great hope about this. It was, I think, lauded by the UNHCR as very promising. And the hope was that a domestic asylum law would soon emerge. However, this draft law of 6617 has been delayed, unfortunately. So we still need to see movement there. And this, again, if we're hoping for greater certainty, which I think we would all want for the individual refugee, but it's also helpful for states, then perhaps this is the way to go if we cannot get to that next level of international commitment to international refugee law. We've also been hearing recently about Egypt, which has does use its own domestic laws in other areas. So, for example, some of the main issues in Egypt are in relation to employment or housing for refugees, but we hear often that there are resourcing issues around this. So while individual refugees might be able to use domestic law on, say, employment or evictions, for example, they often cannot access lawyers who can take these cases to court. And also there's funding issues with NGOs that might be able to do the same. So again, there are other routes in for greater normative protection for individual refugees, but we can say these are still weak. And then finally, a country, just as an example, Turkey, which is signed up to the 51 and 67 protocol, has the famous geographic limitation, which means that it only considers refugees to be those individuals coming from Europe. So again, it uses its domestic legislation, say, for example, in the case of the Syrians, to look at temporary protection initiatives for individuals such as the Syrians. So a usage of domestic law once more, which is a bit broader than, let's say, just issues in relation to refugees. So I conclude then with the slide that maybe opens up for questions as well. I do feel we're at an important crossroad. I think we have to move forward at this point. So we can say we acknowledge and we understand now much better the principles of Islam and how they play in. But we want to do something much more in terms of greater certainty, both for state and for individual. So how do we do this? Well, we might just say, okay, we just accept that the current status quo will remain. But this would be, unfortunately, continue to be quite state-centric. What happens is we have a variation of policies across all these countries. There's not clarity about what will happen when. And that major issue for me is the uncertainty for individuals. So we're seeing much more research. Charlotte has conducted it herself, where we're carrying out interviews with individuals, whether it's in these hosting countries or on the move around the world through Africa into Europe and so forth. And this is giving us a much better understanding of what the individual person on the move, seeking asylum, refugee, requires and desires. So we want this bottom-up approach, I think, rather than always top-down from what the state thinks is best, if we really truly believe in true protection for the individual. So if we do agree that we should move on from option one, well, the second option would seem to me to be for greater adoption of what we call the legal normative framework. And that does mean signing up to binding international refugee instruments, whether it is the Refugee Convention or Protocol, or whether it's binding regional instruments, for example, in the Arab world, the Arab Convention, or in Africa, the OAU Convention, and so forth. Or it could be both, of course. As many countries in Africa do, they are party to the Refugee Convention and the OAU. But we might feel that there's still ongoing issues with this in terms of really states' willingness to commit. And we can discuss the reasons around that much more in questions if that's of interest. So finally, there is this third way, and Islamic Relief have been advocating for this. And that is to develop a protection framework that is clearly rooted in the values, the Islamic values of both host states and forced migration populations. But as Islamic Relief itself has acknowledged, currently enforcement is weak. And so they feel that greater research is needed on this to find ways, maybe through discussion by Islamic states, as to how to best achieve this. Is it through incorporation of those values much more clearly in law rather than reliance purely on the application of Sharia and so forth? Is it through some other form of agreed approach? But there certainly seems to me that if there is a willingness for discussion about this, then there may be movement here to something that is more binding for states and therefore of greater certainty for individuals. So I will close there and open up for questions. Thank you very much, and I'll stop sharing my slides.
Thank you, Dalal, for all the information provided in our subjects for today. Now we're going to open the floor for Q&A session. I will encourage our audience to write questions on the subject of our event, the Q&A bottom of the screen. And before we begin taking questions, Ambassador Khalifa has a comment would like to present before I take the questions. Ambassador Khalifa?
Yeah, thank you very much, Dr. Mohammed. Actually, I have a couple of very quick comments. First, to address the issue raised about the overhead, the issue raised by Dr. Mesfer, and thank you very much for raising the point. It's very important to clarify what we mean by overheads and admin cost. In UNHCR, and it's an organization that is at the center of our discussion today, and the organization I represent, the official overhead rate is 6.5%. It does not exceed 6.5%. But there is a lot of misconceptions about overheads in general. We are talking about refugees, and we are talking about the rights of refugees. Would you consider, for example, the salary of a protection officer who sits with refugees to interview them and issue a certificate recognizing them as refugees in order to protect them within the legal framework? Is that an overhead, or this is actually direct assistance? The staff member who registers refugees in a place like Bangladesh, where the ID card is the only official document those people have, is this an overhead? I dare say that in these contexts, this type of assistance is more important than food, is more important than shelter, is more important than blankets. You can keep giving people this type of material assistance forever without changing their situation. So I appeal to colleagues to reconsider what we actually mean by overheads. And having mentioned that, to overcome this misconception, we have waived the overhead 100% when it comes to zakat. So any contributions that come to UNHCR in the form of zakat, we do not charge anything. We cover the administration cost from other sources, just to close this door about misconceptions. To mention also that this is the second point, that the largest producing countries of refugees in the world are Muslim countries, including Syria and including Afghanistan. Those are on the top of the list. And also the largest host countries are Muslim countries, such as Bangladesh, that hosts the whole population of Rohingya Muslims in the world, such as Turkey, the largest host country in the world, hosting more than 3 million people, such as Lebanon, such as Jordan. They're all Muslim countries. And having said that, as Dr. Dalal mentioned, about 36 member states of the OIC have actually signed the 51 convention. I think it's the Arab countries that are less than 12 who signed the convention. And mentioning the convention, the third quick point is about acceding to the convention. I think this is not the only option that we can consider going forward. There are alternative pathways. I mean, to be honest, whether a country, a government accedes or not, as long as they are respecting the spirit of the conventions. And as long as the legal frameworks within the country provide a conducive environment for refugees to survive, I personally think the issue of ratifying or signing or acceding to the conventions to be a secondary point. I'd rather have a government that respects the rights of refugees without signing than a country that signs without respecting the rights of refugees. The role of regional organizations has not been mentioned at all, neither by me nor by any of my colleagues. The issues that we are grappling with are beyond the capacity of a single organization. We need to speak about the role of regional entities like the League of Arab States, like the Organization of Islamic Cooperation, like the Islamic Development Bank, like the GCC Secretariat. They have a very important role to play when it comes to that.
Ambassador Khalif. Yes, thank you for your remark. We still have some questions coming up now, and I will begin with one question that directed to all panelists in our event today. So one asked the question about those countries who did not sign up in such convention, they still receive refugees or visitors, as they sometimes are being called. Are those countries who haven't signed such convention comparatively could be considered worse or better than those who signed convention?
That's addressed to me?
Addressed to all of you. You can answer this question, or we may take Dalal and we'll come back to you, Ambassador Khalid.
Thank you. Yes. So I don't think it's a question, yes, of saying, are they better or worse? I think as pointed out, what's happened over some time now, with certainly movements, say, of the Iraqis and Syrians into the Arab world, they're becoming much more experienced in handling things. And it's right to say that, as was indicated by the ambassador, that, you know, you may have a signatory country that has signed up, that is actually doing everything it possibly can do to deter people arriving, to exclude, but largely might once people get there, uphold certain rights. I mean, I think the problem is, and it's really interesting what the ambassador said, that he would rather respect the right country that respects the rights of refugees without signing. I suppose from a lawyer's position, there can be a question about that, because there is nothing that you can do to enforce it or to persuade a state to actually be compliant with rights. So it's very much dependent. We couldn't just say, you know, give a straight answer that those who are non-signatory are always doing bad treatment, and those who are signatory are not. It's going to be an individual country situation, and things change over time in relation to politics and influxes of people. So it's not a question that you can easily answer. It's certainly the case that many of the countries that are hosting currently, you know, are not party in the Middle East, for example, and are having to cope with really quite difficult circumstances, and are doing the best that they can under those circumstances with help. So I'll just stop there, but I can come back.
Yes, thank you, Dalal. Ambassador Khalifa, do you still have a comments on the same question? Or I go with the other one?
No, I think Dalal has covered it already. Just to stress my point, it's about the implementation rather than the signing itself. So it's the proof of the pudding is in the tasting, as they say.
Good. We have also another question, which could be follow-up on the just previous question from an anonymous attendees, asking why do still some countries and states still prefer not to sign these UN conventions? Yeah, you can go ahead, Ambassador Khalifa, and we will get back to Dr. Dalal.
It's an interesting question. I wish we have a government representative to answer it, but if you look at it at face value, if you are not a signatory to the convention, you can at any point, and this goes back to Dalal's point about the lawyer's perspective, you can actually deport those people, force them to leave without being in a very clear violation of the international law, because you are not a signatory to the convention. You can consider them migrants, you can consider them violators, you can consider them whatever. But if you are a signatory, then you have legal obligations and you fall under severe criticism when you force people out of the country if they need protection. Probably this is one of the reasons. The second reason is maybe some countries are afraid of the pull factor, that once they sign, that this would encourage more people to seek refuge in those countries, which is a very unjustified fear in my view.
Thank you, Pastor Khalifa. I think Dalal would like to say something about this.
Yes, thank you. Yes, I think that those are two great points, and there are multiple reasons, there are various reasons. So in Arab countries, many of them indicate that they're concerned, they don't want to offer permanent residence. So there's this notion, even though we maybe in reality over many years of hosting populations do remain, and there is this idea that they're temporary and that they will return. So there's despite a willingness to host large numbers, there's this fear of permanence of residence. And that for some of them is very sensitive because it can upset demographic and socioeconomic balances. So example would be Jordan. Now, again, also on the signing or the drafting of the convention, this may still be used as a reason, but I think researchers think, well, it's probably less. But Arab countries have obviously also raised the issue of the Palestinians. So that's linked to this issue of not wanting to grant a permanent stay and the right of return. So that's certainly something that has been raised by those in authority. I would say also, from my experience, there's a bit of a misunderstanding about the obligations in the Refugee Convention. So certainly this idea of return that was indicated just now applies, but also I think some governments are quite fearful that the convention will impose quite a lot of obligations without recognizing or realizing that you can actually enter reservations against quite a large number of the articles in the Refugee Convention. So certainly from my experience, there has been a misunderstanding about that. So you could sign and actually enter reservations on quite a number, not the core ones like non-refoulement or what the definition is of a refugee, but some of the others you could enter reservations. So it will depend on the country, but there are a range of reasons. Thank you.
Thanks, Dalal. We have also another questions coming from Lojane, directed to Charlotte Lisa. The question is asking about how Saudi Arabians' experience with Rafa has different approaches and how these different approaches translated into alternatives chosen by the governments.
Thank you. It's a great question, and I wish we had more time to discuss it. But take the Syrian case, for example, where the government in recent years, or since 2012 in Saudi Arabia, have provided some opportunities for health and schooling and special visitor status for this specific group, and also Yemenis and Rohingyas has been a similar case, where certain assistance is given to people who find themselves inside the country and not being able to return because of the state of their home countries. So this is the visitor or guest approach. And of course, it's very different from the Rafa case, which was a border, more directly on the border and in a neighboring country, and such an immediate case. So I don't think it's that comparable, really. And I think maybe there's misconceptions as well as that a refugee camp will be always the preferred situation from an international community or in connection to the Refugee Convention. And second issue with this approach is that there's no studies looking at how this assistance, while the intention is very good, actually works in the way it's intended. And there's some worrying numbers, for example, in the numbers of asylum applicants with the UNHCR office in Riyadh that is very much on the rise. That might be related to some issues with these systems, but that's, I hope someone will look into that more. And I hope it's a topic that will be subject for further discussions as well. And I'm sorry, our colleague, Dr. Fahad Al-Sharif, could not be here because he's done a lot of work on this as well. But thank you for a great question.
We have also another question from Mujahid directed to Dr. Misfa. And the question is asking about how to transfer and implement the Islamic historical values with respect to refugees in our contemporary days today. Dr. Misfa?
نعم، أعتقد أنه التطبيق العملي هو المحك الحقيقي، لأن الكثير من المسلمين اليوم هناك في انتماء حقيقي للدين الإسلامي من خلال ممارسات الشعائر الدينية المعروفة، ولكن الممارسة العملية لتطبيق العدالة والحماية والأمان وكرم الضيافة للاجئين، أعتقد أنها هي سلوك عملي ينبغي أن يتحلى به كل مسلم مع كل من يعني ألجأته الظروف إلى الهجرة أو اللجوء. فالمحك الحقيقي إذن هو التطبيق العملي لهذه القيم الإسلامية. صحيح إحنا كشعوب مسلمة ربما يعني لدينا الكثير من الظروف المعيشية والظروف حتى الصعبة التي يمر بها الكثير من المجتمعات العربية والإسلامية اليوم، ولكن الحالة السورية، الحالة العراقية، الحالة الفلسطينية وغيرها، حتى الحالة الصومالية والسودانية، كلها أثبتت أن هناك فيه قيم عملية تم تجسيدها في أرض الواقع، وتحلى الكثير من تلك المجتمعات في هذه القيم وخففوا الكثير من المعاناة وفق الظروف والقدرات الممكنة بالنسبة لهم. فأعتقد أننا إذا يعني حققنا مثل هذه المعاني في أرض الواقع فهذا هو التمثيل الحقيقي للانتماء للإسلام.
Shukran, Dr. Musfir. We also have another question from Hiba, who's asking a question about Dr. Dalal's presentation. And she wonders if Dr. Dalal can tell us more about proposals of drafts for domestic laws that will help the refugee status.
Yes, so there's not an awful lot of this in the region. As I mentioned, Morocco is probably kind of leading the way in terms of drafting an asylum law. You might also want to, and as I mentioned, actually that hasn't progressed, so there's a delay on that, unfortunately. So things may move slowly, but hopefully something will emerge relatively soon. The other area is the UAE, and a colleague, Janan Bastaki, has been working on this. So there are laws about migration into the labor mobility laws and so forth, and the offering of visas to the UAE. So they're kind of alternative mechanisms that some of the countries are introducing, which can benefit refugees. So I'd certainly suggest you consider Janan Bastaki's work on this. She's been, as I say, looking at the UAE, and Morocco, not an awful lot there, but everybody else is really still quite reliant on just immigration laws on foreigners rather than domestic asylum laws. So I don't know if that addresses the question or whether it was about other domestic legislation generally.
Well, I was asking a general question.
Sorry?
It was a general question.
Okay, so in terms of just generally domestic law, again, yes, you'll have to look country by country. and some are there's an access issue, so it may be problematic for individuals to access local domestic laws. But on the whole, they should be able to under certain circumstances, but it can be constraining, both from just having standing and being able to do so, and also sort of financial or getting support. So that would apply, I think, across the board.
Thank you, Dr. Dalal. We also
point on that, Dr. Muhammad.
Go ahead.
Yeah, just to mention that Qatar also has a law on refugee protection, and it's the only country in the GCC that has already issued a law on asylum, and we are working with them closely to develop the bylaws and to make sure that it is implemented going forward.
Thank you, Ambassador. We also have a question directed to you, Ambassador, about whether or not there have been discussion on the notion of climate refugees in the Middle East, and that's coming from an anonymous attendee.
I don't know who, I can say a few words about climate refugees if you wish. We are seeing the phenomenon more clearly in other parts of the world than the Middle East. We are seeing it more clearly in Africa, in South Sudan, in Chad, in also Central African Republic. And sometimes it's not about refugees, but about IDPs, internally displaced people, people who are moving from one place inside their country to another place because of climate change, mainly because of droughts and the lack of water. And we have Darfur as a clear case in that respect. I'm not sure about a clear example from the Middle East where people needed to move international borders because of climate change, but we have examples from other parts of the world.
Thank you, Ambassador Khalifa. We also have a comment from coming to me as a message from Her Royal Highness Prince Turki Al Faisal, saying this is not a question, it's an observation. And I'm quoting here, 200 years ago, a lowly Bedouin hosted a man who was seeking refuge in his tent. When those who were pursuing this man came to this Bedouin and demanded that he hand them this man, he replied, quote, "I give him refuge for 3 days. You can come back then to get him." And then end of the quote. This became a convention among all Bedouin tribes in Arabia until today, the 3-day refugee convention. And I may add another question here is how are the similarities between the international law of refugees practice in our day and also those conventions, whether related to Islam or to tribal laws in Arabia and beyond, even before the birth of Islam? And this is an open question to all panelists. I may encourage Dr. Musfir if he has a comment on this.
حقيقة فعلا الرسول صلى الله عليه وسلم لما جاء إلى الجزيرة العربية قال إنما بعثت لأتمم مكارم الأخلاق. الحقيقة كما ذكر سمو الأمير أن الأخلاق العربية كانت متجسدة تماما في الدفاع عن حقوق المظلومين، الاهتمام بالضيوف اللاجئين المضطرين إلى الحماية من أي اعتداء. وكما ذكر سموه أن هذه الأخلاقيات العربية تم التأكيد عليها بعد ذلك في الإسلام. وهذا ما نلحظه اليوم ونحن في المملكة العربية السعودية، بغض النظر عن الاتفاقيات الدولية والمشاركة فيها والمساهمة حتى في دعمها ماديا من خلال المؤسسات الدولية، إلا أن المملكة تمارس أخلاقياتها الإسلامية والعربية في التعامل مع كثير من أولئك اللاجئين أو المهاجرين. أعتقد أن المتحدثة التي تكلمت عن نموذج رفحة هو نموذج واحد، وإلا اليوم هناك ملايين يعيشون داخل المملكة العربية السعودية ويعيشون قريبا من المواطنين ويعيشون حياتهم طبيعية في كثير من الممارسات الطبيعية، حتى في التعلم، حتى في المرافق الصحية، وحتى في الدخول في كثير من المشاركات الاجتماعية. وأعتقد أن هذه الممارسة هي نابعة بشكل أساسي قبل أي اتفاقية توقع عليها المملكة من انتمائهم الديني والعربي.
Thanks, Dr. Musfir. We also have another question is coming from Hiba Al-Baiti, and she is asking if there is any articles in international law that would protect refugees from stigmatization, especially vulnerable ones such as children. I will encourage Dr. Dalal if you know any resources about that.
Yeah, no, I was trying to be quiet because I felt I was being talking too much. So, I mean, clearly there will be a lot of human rights legislation that you can turn to internationally, regionally, domestically, that should provide protection for vulnerable groups. Specifically, when you say stigmatization, that's quite interesting. So a lot of the human rights instruments will be, and the Refugee Convention itself is focused on a principle of non-discrimination. But stigmatization is quite an interesting choice of words. So although we might have quite a range, and a lot protecting children or just everyone as an individual, that should help. When it comes to actual treatment within a country, that is maybe individual to individual rather than state-generated discrimination, that can get more tricky or trickier. So certainly, we would encourage, obviously, that this doesn't happen, but it occurs in all countries. For example, the United Kingdom, for a long time, well, some time ago, introduced a voucher scheme for asylum seekers. And that was deemed stigmatizing because it identified somebody as an asylum seeker when they went into shops to use these vouchers. So even the United Kingdom, which would think, oh, well, we've got a fairly sophisticated refugee law, asylum law, and we've been doing this for quite a long time, does, for various reasons of deterrence, exclusion, or restrictiveness, or whatever, can introduce policies that are stigmatizing. And that may be a little bit more difficult to tackle than something that is very blatantly non-discrimination, but certainly a lot there within the international and regional national frameworks that should provide protection.
Okay, Dr. Dalal, would you be able to refer us to some resources or articles or books within the subject?
Can you leave that with me, and I can have a think and send you a list?
Of course, of course. With that, we reach the end of our events today. I would like to thank all participants and guest speakers with us. In the end of this event organized by King Faisal Center and the University of Oslo, I would like to announce our latest publication for those interested in the same topic as a special reports coming out from the King Faisal Center, titled Saudi Arabia Global Humanitarian and Development Aids. Inside this report, you will find more statistics and data of the Saudi support of refugees inside the kingdom. With that, again, I would like to thank our listener as well as our speakers, and hopefully to see you all in other future events organized by the King Faisal Center for Research in Islamic Studies. Thank you all.
Thank you.